Hello, welcome to our podcast. It comes to us courtesy of the Touro College Jacob D. Fuchsberg Law Center and the Touro Law Review. I'm the host today, Professor Peter Zablotsky. I teach here at Touro. And our guest is Professor Michelle Zachrin. She's also a professor here at Touro. And our topic today is cyber searches, plain view, and officer inadvertence. So, Professor Zachrin, welcome. And why don't you begin by introducing yourself to us and telling us why you became attracted to this topic.
Great. Thank you so much for having me here. It's my pleasure to be here. I have been teaching at Touro Law School for about 18 years. And one of the classes I teach is called cybercrime. And that led me to this. So I have an undergraduate degree in computer science, which I guess makes me a little biased towards some technology issues, especially now that there is an intersection between technology and the law. There wasn't always such a strong intersection, but it's certainly growing. And so in the cybercrime class that I teach, we do discuss a lot of issues, many involving searches and seizures, others as well. But this really struck me when I was teaching, and it just became the basis of an article I just finished.
So you did mention your background in technology. And do you think that gives you some insight as you teach this particular course? I mean, do you think it's helped you develop your cybercrimes course in a way that benefits you and your students?
I like to think so. I think it's more my interest in it than my knowledge of it. Okay. Because I'm interested, I do spend time outside of the classroom reading articles and keeping up to date with certain technology issues just because I happen to be interested in this topic. But I do think it's great for students because sometimes a lot of things that go on in the outside world are really wonderful to bring into a classroom. So it's a really nice balance.
Well, okay, that sounds desirable, certainly. And so, as we focus on the topic of the cyber searches, plain view, and officer inadvertence, there are three phrases in there: cyber searches, plain view, and officer inadvertence, whose meaning really may not be self-evident. So, could you explain each of those terms in any order you wish, as is relevant to your scholarship?
Sure. Yeah, I'd be happy to. Let me define them as best I can for people to understand. So, for instance, when we are dealing with search and seizure law, Fourth Amendment law, typically searches are done, maybe physical premises. We may think of physical premises, like someone's home, maybe the kitchen of their home, the living room of their home, maybe someone's office, maybe a file cabinet in their office or a desk in their office. Those are physical places. And traditionally, that's what judges looked at when they were talking about searches and seizures and when police officers were trying to get warrants to try and search certain locations. Cyber searches, that term refers to more of the digital evidence. So now a lot of people store information on computers, laptops, traditional computers, cell phones, iPads, all different kinds of electronic devices. And so the searches that are done looking into these electronic devices are what is commonly referred to as digital searches or cyber searches, as I typically call them. And so if you think about it, physical spaces have a finite space. They can only look at the file cabinet, let's say. It's more of an infinite amount of space. It's closer to an infinite amount of space when you're dealing with cyber issues. And the questions for the court become, how far should these police officers really go? How far are they allowed to go when they're doing searches of digital evidence? In other words, cyber searches. Can they look at every file in the computer? What should they do? And so this comes up.
All right. So just to again stress the differing context, which does lead to the challenges of the terms that I know you're about to define. So for probably decades, centuries, it was physical space that was the backdrop for developing all search and seizure law. But now, sort of almost at an exponential level, we've gone from rudimentary computers and rudimentary cell phones to just a whole panoply of digital devices, which I think you use an interesting word, infinite, which leads to the possibility of an almost infinite search. And so then that will certainly be relevant to the legal terms of plain view and officer inadvertence.
Right. So exactly right. And so the plain view doctrine refers to police officers' ability to search when they are let's put it this way, when they are somewhere where they're legally allowed to be, either by warrant, with consent of somebody, they are where they're allowed to be. That could be a physical location, that could be a computer, that could be anywhere, but they are technically allowed to be where they are searching already. They have the permission or the warrant, but then they happen to see something else in their view that they weren't particularly searching for. Maybe it was something else, right? Maybe it was, they're looking for tax records and they come across something that relates to drug information. If it's in their plain view, in theory, that should be allowed to be seized and used against the defendant, because the thought is they happened to see it. They didn't really go out of their way to look for it. It just was there. And a lot of times that happens in a physical sense where, let's say, they're going inside of a house to look for drugs, but they happen to see some kind of firearm on a kitchen table, and that just happens to be in their sight. They can take, even though they weren't there looking for the firearm, they can use that firearm against the defendant. That's the plain view doctrine. That's the theory behind it.
And I guess a physical search for data, let's say I'm looking in a file cabinet for some tax records and I see some drugs in there. That's still nonetheless physical, and that's considered also in plain view?
That would also be considered in plain view. Absolutely. That's a great example. And in the digital world, if we just want to give an example of that, in the digital world, a lot of times, if you're looking for tax records that could possibly be, illegal tax records, the likelihood of them being labeled in a file that says illegal tax records is very unlikely, and police know that. So often they're looking at files that may or may not say anything about tax, and they may stumble across information that is equally incriminating, just not relevant to the tax information.
I see. Okay, so if I've set up a business and I'm concealing income, that's not going to be in the concealing income file, most likely, although I'm sure there are such files. But they're looking for something about income, and instead they find information, meaning I'm participating in some kind of illegal immigration scam or something else, and that pops up in there when really what they were looking for was I concealing income as I'm buying and selling cars in my car dealership.
That's exactly right. And if the police officers were allowed to be looking for the concealing income information and happen to see a file that contains the other information that was equally bad, they can use that. That's the plain view doctrine. Very well explained.
All right. Example. And then how about the concept of inadvertence?
Right. So the theory is that the concept of inadvertence is something that police officers, when they're looking for it, there was a time when the Supreme Court had said, you should have officer inadvertence. This is something that we need. This is something that in other words, the police officers have to show that they inadvertently stumbled upon this information. They weren't looking for it specifically. It was completely inadvertent when they discovered it. And then years later, so that's the idea of officer inadvertence, that they stumbled across it. But the Supreme Court in 1990 in Horton v. California held that that's not actually something that we need anymore, that police officers are no longer required under the plain view doctrine to find something inadvertently. That's not something that is necessary or required anymore. And so that is really the subject of what I wrote about, and what I'm talking about today is it or is it not required? The Supreme Court says it's not, but I did a little looking around, little research, and I found that some courts actually are still requiring it.
Okay. So, I mean, is one way of sort of explaining the plain view doctrine is prior to 1990 or earlier in constitutional history, if to be admissible, there was sort of a burden of proof on the prosecution to show that it was inadvertent. I mean, they had that burden of showing that it was discovered inadvertently, but after 1990, all they had to show was that it was in plain view. There was no additional requirement that
That's
it
actually
have been discovered inadvertently.
That's
Is that
true.
right?
That's right. And the Supreme Court said inherently in a plain view search, inherently, there should be this inadvertency in there. We don't need to take the step further and actually show it or require it, because plain view means you weren't looking for it and you happened to just find it. So really, why are we adding this additional burden to these searches? So right after 1990, there was no longer that need to show that in order to take the evidence and use.
But now your research and thinking on the subject leads you to conclude that the situation has changed. I mean, the cyber aspect of this may need to result in a change in the doctrine on inadvertence, and that's what the courts are now addressing in some fashion.
Yeah, that's exactly right. That's exactly right. That I noticed that even though the Supreme Court clearly said the words that inadvertence is no longer necessary in these kind of searches, what I noticed is as the courts, some courts, and we can talk about which ones, but some courts, as they were looking into these questions that came up that were cyber searches, that where they were searching for digital evidence, they seemed to start to put this requirement back into the analysis.
Okay.
And part of their reasoning seemed to depend upon whether the officer inadvertently discovered it or not, even though the Supreme Court said that's no longer required. And it just made me wonder, why is this happening? What's going on?
Well, you mentioned that maybe there are a couple of courts that are taking the lead on this. And why don't you briefly, excuse me, why don't you briefly summarize for us what you think are some of the key circuits or any other sort of tangential Supreme Court case that might be relevant to this dynamic that's developing?
Sure. Okay, so what I realized is starting in 1999, the 10th Circuit really took the lead on this, but in a case called Carey, looked into whether a police officer's search of digital evidence was what was discovered, even though it was different from what the officer was looking for, if what was discovered was allowed to be used against the defendant. And in reaching the decision was about whether the police officer found the information inadvertently or not. And that was the reason behind the holding. And then two other 10th Circuit court cases after that also looked at digital searches of computers, searches of laptops, looking for files. And again, based on the original Carey case from the 10th Circuit, looked at that reasoning and again, decided same thing, depending upon the level of inadvertence, if there was inadvertence or not of the police officer's search, that was the answer. That was the holding of the court. It was directly dependent upon the officer's inadvertence or lack thereof. And so it started to develop from 1999 through the early 2000s. It started to develop. And so if we think about when the Supreme Court said this is no longer required, that was in 1990. That was really before there were a lot of these digital searches, these cyber searches, and a lot before people were really storing everything on computers. Maybe the Supreme Court hadn't at that time envisioned that something like this would happen. But it seems to be happening in the cyber world. And I was questioning why is the 10th Circuit just completely putting aside what the Supreme Court has said and just deciding on its own to now require inadvertence again.
All right.
Yeah.
So if I may, so the 10th Circuit then, they seem willing to exclude evidence if it wasn't discovered inadvertently. They said, in other words, if they've elevated that requirement and said, well, we can't find inadvertence here, so you can't admit this, or by contrast, you can't admit this because there is inadvertence present. Is that correct?
That is correct. And I'll tell you what's interesting is in 2019, the most recent case I could find, a case called Loera, based its decision in the 10th Circuit on the three prior 10th Circuit cases and noted specifically that we know, I'm paraphrasing, but we
Okay.
recognize that the Supreme Court has said no, that we don't need officer inadvertence. However, since we have held this way in Carey and the other two cases, we're going to continue to hold this way. And the court even specifically used the words like digital and physical, and did make a note that it seems to be because there might be some correlation between the fact that these searches are digital, not physical searches, and using this term inadvertence and
Okay.
requiring it. But the 2019 case did actually note that the Supreme Court said we're not requiring it, yet they're still doing it. So
All right. So it was basically an overt recognition. I guess to the 10th Circuit, it sounds like they're a leading circuit in this regard. What have the other circuits been doing? Have any of them said sort of overtly, no, we're going to stay with the traditional, I don't know, traditional, the 1990 Supreme Court view that inadvertence is not relevant to our understanding? Have any circuits gone the other way on this?
Yes, but I want to first say that there are a few circuits that are agreeing with the 10th Circuit. So
Okay.
the 6th Circuit, the 7th Circuit, and the 9th Circuit and the 11th Circuit have all held in some way that inadvertence is a condition that we should look for
Okay.
in deciding these cases. In contrast, the 4th Circuit has come out and said, we know what the 10th Circuit's doing, but we can't do that because the Supreme Court says it's not required. So we can't require it. So the 4th Circuit stands alone right now, but is following the Supreme Court precedent and not making any kind of change, but acknowledging that other circuits have not gone that way. But the 4th Circuit wants to stay with the Supreme Court case. And that case is the Williams case from 2010.
Okay. So then, there is still nonetheless a split in the circuits. Even one circuit going in a different direction certainly constitute that split. You mentioned that the earlier Supreme Court case wasn't really analyzed in the context of the exploding digital world in which we currently live. Did the Supreme Court ever decide any case in the context of some of the earlier technology, be it a cell phone or a fundamental business computer or something like that?
Yeah, actually, the Supreme Court has looked at technology. So the Supreme Court has never decided this type of issue that we're talking about here, about officer inadvertence,
Okay.
cyber cases, plain view. That not yet, maybe one day. But the Supreme Court has certainly looked at cases involving technology, and time and again, the Supreme Court has noticed that things are different as technology grows, and laws have to be a little different as technology grows. And there are a few cases, the Kylo case from 2001, the Riley case from 2014, and the Carpenter case from 2018. And I think most notably, the Riley case is where the Supreme Court says this in a lot of the cases, but in the Riley case in particular, that was a case involving a cell phone and a search of a cell phone.
Okay.
And that case had to do with incident to arrest, a search incident to arrest, which is a little different from plain view, but theoretically, police officers, upon making an arrest, can do a search of the person. And if there's something on the person, like in the person's pockets or something, the police officers have always been allowed to search that too.
Mm-hmm.
And then cell phones came along. And so courts were wondering and police were wondering, can we search arrestees' cell phones incident to arrest? And that was a big question. And so the Riley court found that you can't search it automatically incident to arrest, because what was interesting about the language was the Supreme Court saying cell phones are different. They're just different. They're different from other types of things that we would search, physical things we would search, and the storage capacity is so vast. They're almost like what the Supreme Court called mini computers. And it wouldn't be right to be able to search them automatically. That doesn't mean you can't get a warrant. And if you have reason to search it, that's a whole other story. You absolutely, that could be done, but not just because it's incident to arrest, which is what used to be the holding before the technology came along that made cell phones, basically hold such a vast amount of material. So the Supreme Court has spoken on technology and has recognized that there are great differences when searching technology or using technology than there are to, non-technological searches or uses.
That's very interesting. I mean, I certainly can imagine, if I have a bag in my pocket, that's finite. There can only be so much in it. If I have a cell phone in my pocket, it would be moving vans full of bags. There'd be so much data in there.
Exactly.
And has any of these circuits, as they struggle with this, trying to draw on any of these Supreme Court technology cases, let's say Raleigh, for example, by analogy and saying, well, the Supreme Court has recognized that technology is different, citing Riley?
Not yet, not that I've seen, not yet, but it does seem to be that that's the way the Supreme Court, in my opinion, that's the way the Supreme Court's trending. But no, I don't know that it's been cited that way yet, but I see that as a reason. I mean, the 10th Circuit, when it started its holdings about inadvertence, were way before the Supreme Court spoke about any of the technology. That was 1999, and that was even before. But the more recent cases certainly could analogize that way. But it's interesting that it seems to me that the 10th Circuit maybe had this vision of what could possibly, right? What could possibly be that there's something different about these searches of computers, and we're trying to protect maybe from police going a little too far. It's really easy to just click another link, click another file, open another picture. It's very easy for anyone to do that if they're already in that computer.
That's interesting.
Right? And I think that maybe the 10th Circuit recognized that couldn't have been what the Supreme, we need it to be inadvertent. That couldn't have been, there has to be some safeguard there. At least that's what I think. I'm not sure I agree that the right way to do it is just to disregard the Supreme Court's precedent. I'm not sure that I could say that's the best way. I think the Fourth Circuit has its own right way because it's following what the Supreme Court says. But I do understand the reasoning of the 10th Circuit. So there needs to be some kind of solution here, right? Like there needs to be, I hope, one day soon, the Supreme Court will hear a case involving the digital search and officer inadvertence and plain view, and hopefully make a determination. Is the 10th Circuit, along with some of those other circuits, right? Is the Fourth Circuit right for following the Supreme Court? Originally, it's a tough, I look forward to that day. I hope it happens soon.
So I mean, obviously you're not bound to simply recite cases here. You're completely free to state your opinion. It sounds to me like you believe, as a matter of jurisprudential philosophy, Fourth Circuit's sort of right that we need to follow the Supreme Court. But as a matter of how search and seizure law ought to evolve in the context of cyber search, plain view, and inadvertence, the 10th Circuit is as the most realistic and even visionary view of where this law needs to go. Is that a fair way of saying your opinion, which again, you're totally free to express here?
Right. No, that's exactly how I feel, actually. That's exactly how I feel. I feel like the 10th Circuit and the other circuits have it right, but the Fourth Circuit also has it right because procedurally that's probably the right way to go. I don't think it's ever, the right thing to just, not do what it's doing. But it's good to see why, if we look into why the 10th Circuit is doing what it has been doing and why the other circuits are following along, it does signal there's a need for change, right? It signals something. We need change. We need to evolve. We need to have some of these laws catch up to the technology. It's hard. Technology is so quick, right? It's always changing so quickly. So we do need to evolve a little bit faster, maybe, but I do see, I see both sides, I guess you could say.
Yeah, but I understand what you mean. You see both sides, but they're sort of different issues. One is more of a procedural issue. One is more of a substantive issue, both critical, as any, law student knows. You got to study both. Well, that's very interesting, and it seems inevitable that we'll have a Supreme Court weighing in on this matter, either directly or indirectly. And so I guess you, for one, very much look forward to that day.
I do. I look forward to that day. I hope it happens soon. I hope there's a case coming up one of these days and, cert is granted, but we'll have to wait and see. But that's what I would suggest, is that the Supreme Court, if anyone's listening, Supreme Court, that would be a good case to take up and give some guidance to these circuit courts that really aren't quite sure what to do.
All right. Well, thank you, Professor Zachrin, for defining these terms and setting this very important dynamic as opposed to constitutional law, evidence, criminal law. We appreciate you coming on, and thank you very much.
Thank you. Thanks for having me. It was great to be here.